This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about indemnification and the use of terms in indemnification agreements like caused by or arises from, and whether or not those terms are synonymous. In John Caruso versus Omni Hotels, DBA Omni Hotel, Ultimate Parking LLC, the United States Court of Appeal for the First Circuit on March 2, 2023 resolved, with reference to insurance law, an indemnification agreement between a hotel and its valet operator. The case arose when Mr. Caruso, while staying at the Omni Hotel in Providence, Rhode Island, was injured when he tripped and fell on the curb that separates the hotel's valet driveway from its main entrance. Caruso sued both the hotel's valet operator and the hotel's owner, Omni Hotels Management Corp., blaming his accident on their allegedly negligent maintenance of the premises and the allegedly dangerous driveway curb. After the valet operator Ultimate settled the case with Caruso on behalf of itself and Omni, Omni sought indemnification from Ultimate for its attorney's fees. The district court granted summary judgment for Ultimate on Omni's indemnification cross-claims, holding that neither the parties' contractual agreement nor Rhode Island common law entitled Omni to such relief. Caruso's accident occurred on May 2016, and his suit alleged that Ultimate had negligently parked vehicles within and up against the curbing of the valet circle and thereby caused or contributed to causing him to trip and fall and sustain serious personal injuries. Ultimate operates the hotel's valet and parking services pursuant to a contract with Omni that includes provisions in which the two companies agreed to defend and indemnify each other in certain circumstances. Both defendants moved for summary judgment on Caruso's claim, but the district court denied the motions on the grounds that a fact finder needed to decide whether either or both defendants were negligent and whether any negligence was a proximate cause of the plaintiff's injury. The district court ruled that the contractual exclusion for a claim that arises from Omni's negligence, intentional acts, or misconduct was triggered by Caruso's allegations only, that Omni's negligence contributed to his fall and injuries. The court also rejected Omni's common law indemnification claim. The First Circuit, in analyzing the issue, challenged the district court's indemnification rulings and the court's earlier denial of its motion for summary judgment on Caruso's negligence claims. Omni further claimed that even if it is not entitled to contractual indemnification, common law indemnification applies here because Caruso alleged active negligence on Ultimate's part and only passive negligence on Omni's part. Rhode Island courts have long treated indemnity provisions as valid, if sufficiently specific, but have directed that such provisions are to be strictly construed against the party alleging a contractual right of indemnification. The district court rejected Omni's argument that a judicial determination of negligence on the part of Omni is required before indemnification is precluded. The First Circuit disagreed. It noted that Rhode Island law draws the distinction in terminology on which the district court relied. Rhode Island cases reveal that the state's courts would review the words arising from as used in the concession agreement as largely synonymous with caused by. The view that arising from may be synonymously used and interpreted with caused by also is reflected in cases addressing indemnification provisions in insurance policies. Another context in which one party, the insurer, typically is assigned the obligation to defend and indemnify the other party, the insured, based on an underlying negligence claim. The expression arising out of indicates a wider range of causation than the concept of proximate causation in tort law. But such variations in the breadth of causation play no role in this case, where the debate concerns the need for a finding of negligence versus allegations of negligence. The First Circuit opined that Rhode Island's Supreme Court would treat the concession agreement's reference to an injury that arises from a negligent act no different from a provision referring to an injury that is caused by a negligent act. Arises from, in the pertinent phrase of the concession agreement, carries materially the same meaning as caused by. It would make no sense, at least according to the First Circuit, for the concession agreement to excuse Ultimate from its contractual responsibility for its own actions based on a third-party allegation against Omni that, as a factual matter, were meritless. The concept of indemnity is based upon the theory that one who has been exposed to liability solely as the result of a wrongful act of another should be able to recover from that party. Only the indemnity's sole negligence would negate indemnification. In a business contract, the agreement to defend and indemnify is incidental to the main purpose of the agreement. The pleading test for insurance coverage also recognizes the unequal bargaining power that often exists in that contract, another contrast with commercial agreements executed between two business entities. Ultimate's obligation to indemnify Omni for expenses and judgments of every kind whatsoever, with the exception for claims involving Omni's own negligence, and then refers specifically to the obligation to employ counsel and provide a defense. The commitment to indemnify Omni is negated only, in fact, if Omni bears some culpability for the third party's alleged harm, a finding that, to this point in the litigation, has not been made. Ultimate waived any argument against Omni's theory that it is entitled to indemnification because no fact finder could attribute Caruso's fall to the negligence of Omni. The First Circuit, therefore, vacated the summary judgment for Ultimate on Omni's contractual cross-claim for indemnification and remanded the case to the district court with instructions to enter judgment for Omni on that claim after whatever proceedings the court deems appropriate to determine the amount due to Omni. In my opinion, like an insurance policy's promise to indemnify, the agreement between Ultimate and Omni contained a promise from Ultimate to indemnify Omni if its actions caused Omni to be sued. Since Omni did nothing to cause Caruso's injury, it was entitled to indemnification regardless of the fact that Caruso alleged, but did not produce evidence to prove that Omni was negligent or contributed to Caruso's injury. The use of language, quote, arises from, close quote, was logically found by the First Circuit to be synonymous with, quote, caused by, close quote, and Ultimate, or its insurer, was obligated to defend and indemnify Omni. This video was adapted from my blog, Zalma on Insurance, which is free to anyone who clicks on the URL zalma.com/blog, where you can subscribe to the blog posting and thereby be advised daily, at least 5 days a week, of every blog posting. You can also view these videos on rumble.com or on youtube.com and can subscribe to the videos as well. If you found this blog posting and or video to be of interest or use to you, please tell your friends and colleagues so that they can also subscribe, and also consider whether you wish to subscribe to my Locals community or my Substack publications. Thank you for your attention.